Supreme Court will soon issue a ruling that could reshape the balance of power between federal agencies and the judiciary. It could also disrupt President Joe Biden's progressive regulatory agenda. The nearly 40-year precedent, known as the Chevron doctrine, tells courts to defer to federal agencies' reasonable interpretations of ambiguous statutes, which many businesses and industry groups say has led to stifling regulations. Conversely, the federal government contends the precedent respects courts' authority to interpret law while also respecting Congress's ability to delegate power to agencies in the executive branch. The cases before the High Court, Loper Bright Enterprises v. Raimondo and Relentless Inc. v. Department of Commerce, were brought by two fishing companies challenging a national marine fisheries service mandate that forces their fishing companies to pay and house at-sea herring monitors. The fishing companies argue Congress never authorized the NMFS to require commercial fishermen to pay for at-sea monitors, highlighting a central issue to the Chevron debate: the extent of agency authority. The primary complaint by industry groups and businesses is the Chevron doctrine makes it too easy for each new administration, whether Republican or Democrat, to change their interpretation of federal law and introduce systematic bias into the adjunction of cases. The defense's main argument is agencies are filled with experts in their field, and it makes far less sense for a judge to be interpreting ambiguous statutes when there are designated experts who might be better suited to interpret statutes. Justice Elena Kagan highlighted the challenges Congress faces in foreseeing future issues.
Chevron is about what Congress wants. And you can call it fictional all you want, but we have lots of presumptions that operate with respect to statutory interpretation. And this is just one of them.
Ketanji Brown Jackson also raised concerns about the judiciary's role if Chevron were overturned.
I'm worried about the courts becoming uber legislators.
On the other side, Justice Brett Kavanaugh underscored the instability Chevron brings, such as allowing new administrations to reinterpret laws differently, thereby shifting regulatory landscapes dramatically.
Historically, under the Constitution, to police the line between the legislature and the executive, to make sure that the executive is not operating as a king, not operating outside the bounds of the authority granted to them by the legislature. You agree that's a proper judicial role, I would assume?
I, of course, agree with that.
The High Court's decision is expected by the end of June.